Hey, Rick,
Hey,
thanks for doing one of these again. I think
sure.
if we keep hearing it, we're going to actually get it.
That's the plan.
Just keep telling us, just keep saying it.
This is funny. Oh, all right.
Hi, Rachel. How are you?
I'm fine. I'm fine. Uh, let's see. Okay. Oops. Keep going. All right. All right. So
Mm,
let's keep going.
okay.
Okay. All right. So as you got the email, what this is about is the listening agreements, how to present the listening agreement in post lawsuits. And why is it different? I mean, it may not necessarily be different from the way you do it all the time, but here's what the lawsuit was. It actually was sellers, class action lawsuit sellers, who claimed that who claimed that they had no idea they had no idea that they were paying the other broker, paying their adversary, paying for the broker who represented the buyer. I had no idea. So, and another thing is that there was no transparency, and I was told that this was what the commission was, and that's it. There was no discussion regarding commission. So that's basically what the lawsuit was about. And as you all know, the plaintiffs, KW included, excuse me, the defendants, KW included, uh, were found guilty. I don't know if that's the right term in a civil lawsuit. I'm not a lawyer. Um, and I will just ask, I'm gonna ask if iPhone, I'm gonna put you back in. If you would just identify yourself, like name yourself, I'm gonna move you back to the waiting room, and then put your name in. Okay. So anyways, that's basically what that lawsuit was about. Um, and they want to uh we said it really wasn't a transparent transaction. So when you're doing a listing presentation, you're going to be transparent as all get out. Let's just look at this. So let me see. Um, Wait, I'm just gonna hold on one sec. Okay. Um, so let me share. Hold on. Let me share. Do this. Let me do this. I'm gonna find it. Hold on. Where are you? Where are you? Where are you? Hold on. Darn. Okay, let me go to this one. Okay. All right. So what you're looking at is the residential listing agreement, the RLA, and sorry, there keeps being people wanting to come in, and now I lost the sorry. All right. So this is the there we go. Residential listing agreement. Okay. Date it, the date you're preparing it, not necessarily the date that it's going to be signed. Now that we only accept in the offices an exclusive right to sell. What does that mean? That we are the only one authorized to sell it. There are open listings out there. They do exist. But our brokerage and normally other brokerages do not allow that. So we want to have exclusive right to sell. You don't want a listing out there that anybody can, turn around and sell it from out under you. So the seller's name goes in up at the top, and if it's an entity, it's the name of the entity, like a trust or whatever. That goes at the top, and the broker is the brokerage. It is not your name. It is the name of the brokerage, and it has to have a beginning date. Now, a lot of people say, "Well, it's not going to be ready for a week, and I'll date it in a week's time." I don't suggest doing that. I would date it that day, um, and then it has to have an end date. Why would I date it that day? Because if you dated a week or two or how many days in the future, another agent can come around and say, "Hey, I hear you're thinking of selling your place, and I may have a buyer for it." And, well, I have a listing agreement. Oh, really? It's now because I don't see it in the MLS. Oh no, we're waiting because I'm not 100% ready, so it doesn't start for a week. Oh, really? My buyer doesn't care. If you let me bring him in, and maybe we can get this done right here, right now. And there's nothing wrong with that scenario. You don't have a listing agreement with that seller until that start date. So that's why I would date it the date that you are sitting down and having it signed, exclude it for the week that it needs to be off the market, and you now have a valid listing agreement. So make sure that you do that. I mean, that's the recommended course of action. So anyway, so it needs a start date, it needs an end date. I'm going to tell you right now that starting, oh gosh, I put those paperwork away. Oh, somebody has a question. Do you still use? Yes, we still use the SCLM, even though if you're with CRMLS, they just register it. They may at any time ask you for that paperwork for the SCLM, and you need to include it, and it needs to be signed by the broker or the manager of the office. The agent does not sign an SCLM. I can't remember. I'm going to be going over some new laws that the governor signed, and one of those new laws that the governor signed is that you cannot write a contract for more than 2 years. it cannot be a contract to sell cannot be longer than 2 years. Meaning, if you have it for a year and you extend it for a year, that's it. That's all you have. And why are they doing this? It's all because of these companies that were writing 40-year listing agreements and then putting a lien on the property, giving the seller money at the time, but saying, I'm going to have a listing agreement with you for 40 years. And so whenever you get a chance, whenever you decide to sell it, you have to come to me to sell it. And because I gave you some money up front, and if you don't, then I have a lien on your house, and so it was a real mess. So so that's why. So the governor has signed this law into effect, but I don't want to say it's in the future. I don't think it's January of 2024. I think it's later than that, but I'll go over this with each office as it is. Okay, so we've got the parties, we've got the length of time, and then we have this is an exclusive and irrevocable right to sell or exchange the real property described as. I want to stress irrevocable. What does that mean? That means it cannot be canceled unless we all agree to cancel it. That's what it is. That's why when somebody says, "Oh, cancel my listing," blah 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 blah. Why are we canceling it? And I've had people. It's been on for 2 days, and they, "Oh, I want to cancel." Oh, they changed their mind. It's like, you know what? It's a contract. You have to go over this stuff. That's not to say that I'm not going to cancel it, but just make sure that they realize this is a contract and it's for this amount of time, and it is binding, and we have to mutually agree to cancel it. Okay. So that's next is the address. It has to go in the address and the parcel number. If it's a manufactured property, a manufactured home, a mobile home, you will check this box, and then it will automatically produce another form. Then if it's being sold as a probated conservatorship, guardianship, you would check this, and it also will create another document that you need to deal with from them. Listing price and terms, very important. You have to put a price. The basics of a contract is that there needs to be some offer of compensation, offer of some consideration given in order for it to be a valid contract. If you don't put a price on there, it's as you've learned in real estate school, it is voidable, meaning you take it to court, they can they can fight that, and they can possibly get it voided, and you're out. So make sure there is a price there. Don't leave it blank. Don't say to be negotiated. It has to be a dollar amount. So that's why it says dollars. Listing terms. Well, what would you put in listing terms? That you can put in. I've had agents lately who had a listing, and they paid for stuff, or and they want to be, if it cancels, they want that money back. You could put that here. You could put that broker and seller agree that that contract can be canceled with the 45-day or 48-hour notice, or whatever the terms. Those are some of the things that you can put in there. So Now, this next section, compensation, is the most important section that we're going to talk about today, is because this is the crux of this lawsuit. Now, yes, the lawsuit took place in Missouri. I don't know what Missouri's listing agreement looks like, but my guess, it looks kind of similar to this. And you know, it's not, it's disingenuous for the sellers, I think, to say, well, I didn't know. So number three, compensation to broker. And this, it has to be, you'll notice that it's bolded. So, and it has to be at least 10 points and bolded fonts. That's a requirement by California law. So the amount or rate of real estate commissions is not fixed by law. Please go over that with the seller. We do not fix our commission rates. They are set by each broker individually and may be negotiable between seller and broker. Real estate commissions include all compensation and fees to broker. So, one important sentence here, they are set by each broker individually. What you can't say, all the brokers in this area have determined that the compensation is 6%. You can't say that. Why? Because that is against antitrust laws. And you're basically saying that brokers have colluded and said, all of us are going to charge this amount of money. But you can say, my office asked me to get a commission on my listings of 6%. But that commission includes, and this is very important, compensating the buyer's agent. Because you don't want to give them the impression that you're getting the whole 6%, and you want to make it clear that they will be compensating the buyer's agent. And if they say, I don't want to do that, then they don't have to do that. You cannot say, well, but that's the way it's done. You can't say that. That's number one. If I can get that through you, that it's these things are not set in stone. They are suggested by your office, your individual offices. We suggest that you offer 2.5% to the cooperating broker, because now we're in this thing, guys, where if you're representing a buyer, you're scrambling if the seller's not offering compensation, so you have to get a buyer broker agreement, all this stuff. So we want to do this right. And in fact, by the seller offering the buyer's agent, they're paying the commission to the buyer's agent, it does a couple of things. It will expose the property to a larger group of agents to identify it, to show it. Also, it's very important that in right now, currently, commissions cannot be financed, so it may limit the pool of buyers, because then they would have to pay for the buyer's agent commission on top of their commission, on top of any other closing costs. So those are a couple of factors why a seller might want to pay that commission. Now, if the client asks, why do you suggest 2.5? What is the suggested response? The suggested response is that my office asked for 2.5 compensation, and a buyer's agent is more likely. No, I don't want to say that. 2.5% is the standard that my office asks. That my office asks for us to offer the other side. That's all you can say, really. That my office asks that when offering a cooperating broker compensation, my office asks that the compensation be 2.5%, in hopes that buyers agents will show those properties over other properties. I mean, it's kind of a fine line. It's a gray area, because you don't want to say, well, nobody's going to show it, but you have to say, you have to give some reasoning. So I think that's the way I would do it. So now we've gotten to compensation, so have the discussion. Okay. My office asked me to get 6%. Feel them out. Okay. What about 5%? And then offering 2.5% to the other side. This is called negotiating. Get your negotiating skills out there, because you're going to be doing it on both sides now. So that's what, and you would put the total amount of compensation that is being paid. Now, if the seller is only paying for their side, so whatever that is, if it's 2.5, if it's 2, if it's whatever that is, it is. Excuse me. Also, going back to listing terms, this is probably where you would put that if the listing agent, and I would even name yourself, if the listing agent, Rich Pisani, represents both the buyer and the seller, total commission will be reduced to 4%, or whatever you negotiate. Once again, it's a negotiation. So if you're double ending it, now remember, the listing belongs to the broker. So another agent in your office represents the buyer. That's a dual agency. So you don't want to say, if the broker represents both buyer and seller, then you're reducing the commission. You have to be specific to yourself. Is that clear? Any questions on that? All right. So that's 3A is the total percentage. 3A2 and 3A1, let's just go over. If during the listing period or any extension, broker, cooperating broker, seller, or any other person procures a ready, willing, and able buyer whose offer to purchase the property on the price and terms is accepted by the seller, provided that by the buyer completes the transaction. This was added years ago. It used to kind of stop at procuring a ready, willing, and able buyer. You automatically owed me the commission. That's not the case anymore. The contract was changed. And no, Monique, it's a negotiation. There is no highest commission. She asked if the 6% was highest commission. It's negotiable. You can get more than 6%. God bless you. I mean, you can get whatever you want. I don't know that. Well, I mean, if somebody was willing to pay, then that's fine. So once again, the sale has to be complete, and that's when the commission is owed. Number two, this is the safety clause. If within X calendar days after the end of the listing period or the extension, so a lot of people just the same amount as what the listing period was. If it was a 90-day listing, they'd have 90 days. Once again, negotiable. Go over this contract. So I was talking to somebody the other day, is like, I tried to do a buyer broker agreement, but they won't sign it. I sent it to them in DocuSign and won't sign it. I told them that if I get paid by somebody else, then they don't owe it. I said, but did you go over the contract with them? Just telling them that is in there isn't enough. When I had a buyer and I was writing up an offer and I was sending it to them on DocuSign, and nowadays we have Zoom. If I was sending it to them on DocuSign, I was on the phone with them and I was saying, okay, let's go line by line here. This is what this means. This is what this means. Okay, we're at the end of this page. You're okay with that? Let's initial it and then go to the next page. And that's how you should be going over these contracts if you're not sitting with them and going in over it. We have to be educating our buyers and sellers, and it's our duty. This is part of our worth, that we know these contracts and we go over them and explain them as best we can to our buyers and sellers. Now, if they have legal questions, you have to refer them. You're not a lawyer. You have to refer them to their own real estate attorney. So back to 3A2, and that's within X calendar days after the listing period or extension, after any cancellation of this agreement, unless otherwise agreed, seller enters into a contract to sell, convey, lease the property. I'm paraphrasing, that person's related entity who physically entered and was shown the property during the listing period or any extension or any cooperating broker, or for whom the broker or any cooperating broker submitted to seller a signed written offer to lease, exchange, blah, 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 or any broker has given seller a written notice of the names of such prospective buyers. So what does that mean? When this is over, either by listing or cancellation, you're going to give them a list of the individuals or the cooperating brokers that entered that property, that wrote an offer, and say, if during this period, after this expires or after this is canceled, any one of these people write an offer and it's sold, you still owe me the commission. And that's what that says. If the buyer comes to the listing agent and wants you to rep them, but seller is unwilling to pay their commission, will you just give them a buyer broker and charge a buyer fee? Yeah, you would. Yes, absolutely, because you got to get paid somehow. So yeah, you need a separate agreement with them for compensation. So yeah, the answer to that is yes. 3A3, if without broker's prior written consent, the property is withdrawn from sale, conveyed, leased, rented, otherwise transferred, or made unmarketable by a voluntary act of the seller during the listing period, you are still owed the commission. Okay. 3B, if completion of sale is prevented by a party to the transaction other than the seller, then compensation which otherwise would have been earned under paragraph 3A should be payable only if and when seller collects damages by a suit, arbitration, settlement, or otherwise, and then in an amount equal to the lesser of one half of the damages recovered or above compensation. Basically, if the buyer backs out, defaults, the seller sues, and they get an award, then you as the broker, or the broker, is entitled to half of that award. Now, here's the sticky point with that. The sticky point is that, well, you hope that you would still be able to represent that seller and sell the property to somebody, and then how do you think that seller is going to feel when you want half of the money that they got? So that's a business decision. What if the seller is not cooperative in signing off on the list of the buyers? There's nothing that says that they have to sign off on the list of the buyers. It always says you have to supply them with a list. So, in addition, seller, we're in 3C. In addition, seller agrees to pay broker. If for those of you, especially in Calabasas, you have an opportunity, if you can offset your if you're representing no, you can offset your fees for legal, transaction fee, and an in-house approved TC by charging a flat fee commission. Many brokerages, for those of you who've come from other brokerages, many brokerages they charge a flat fee commission. When I was at Rodeo, it was 500. So that's in a listing agreement. That is where you would put that amount, whatever that amount is. I know that in the KW addendum for Calabasas, I think it's 575. It's for the buyer. So the alternate of that is yeah. What exactly gets covered by the flat fee of 575? I just told you the transaction fee, the legal fee, and the fee of office approved TC. So that's what gets covered. Okay, seller D. Seller has been advised by broker policy regarding cooperation with, and the amount of cooperation, compensation, offered to other brokers. Broker is authorized to cooperate with and compensate brokers participating through the multiple listing service by offering the MLS brokers out of brokers compensation. This is where you explain, you're paying 6%. I'm giving X amount of percentage to the cooperating brokers. So that's what you would put in, either by a percentage or a flat fee. So that makes sure that when you're talking about item number 3A, you're talking about item number 3D also. What if there's not a TC on the file? Does the agent get the balance of the money? You asked me that just to me. I know I'm going to say this, I know for a fact that you were given that amount, but it never should have happened, in my opinion. And it is only to cover the fee of a TC. If you do your own TC work, then it should go to the office. This is the office allowing you to pay, pay for some of your services that you pay, so it doesn't come out of your pocket. But if you're not paying a TC, I don't think it should be extra money in your pocket. So that's my opinion. Maybe the next time it won't be that way. So just because it was done once, don't expect it to be done every time. Seller's been advised. Oh, that's cooperative. Okay, so we're into E. Seller hereby irrevocably assigns to broker the above compensation from seller's funds and proceeds in escrow. All that E is saying is that you can take from my proceeds and pay the cooperating broker. That's what E says. F says seller represents that seller has not previously entered into a listing agreement with another broker regarding the property unless specified as follows. So if this was listed prior by another broker, you would name those brokerages here. And then number 2, seller warns that seller has no obligation to pay compensation to other broker regarding property unless the property is transferred to any of the following individuals. Well, guess what? The list that you give to the seller, this is where that list should be given. That list should be, if that other broker gave the seller a list of these are the people that if you sell it to these people, I get the compensation, then that's where these names go. And if it's a long list as an addendum, then you do the same thing. Okay. So F3, if the property is sold to anyone listed during the time seller is obligated to compensate another broker is not entitled to compensation under this agreement, and broker is not obliged to represent the seller. Basically, okay, you owe the compensation to XYZ brokerage. XYZ brokerage can now take over this transaction. So that's the first page. Any questions regarding that first page? Not seeing any, and that's the most important page. So if you have any questions, then let me know. Items excluded and included. Please make sure that you fill this out. If the seller wants grandma's chandelier, and they refuse to take it down, although you're really recommending that they take it down, then they should write that there. Included, you can write if they're including certain furniture or the washer and dryer, something that can be easily taken away. If it's a fixed, it's a part of the property. But if it, like the refrigerator, that can easily go. And so I would put that. Now, just because things are written here and things are written on the MLS, when you actually get these offers, make sure it's clear on the offer. If the seller wants that chandelier, make sure that on that one of these counter offers, that the chandelier is excluded. Make sure that just because it's in the MLS doesn't mean the MLS isn't the contract. Make sure it's on the contract. So 4B, leased or not owned items, solar panels and stuff. Sometimes those are not owned. So you would just check those and said seller will provide the buyer as part of the sales agreement copies of these lease documents and other documents obligating seller to pay. So make sure that you know that if it is leased, you better know it's leased and make sure that this is the time to go over it with the seller. Smart home features. We all have these smart homes, and guess what? Some of the control pads are nice little iPads, and sellers, oh yeah, I want that iPad, and they take it with them. Well, that all has to be it all has to be ironed out, when you're taking this listing. So make sure that you're doing that. Let's see. Somebody's asking a question. Should the agent handle it? Should the buyer be interested in buying the seller's personal? All you do is you can negotiate it, and then you can, on a separate addendum. Sometimes lenders don't like that. It's going to have to be lender by lender how it's handled, but you list what is going to be included, what personal items are going to be included in the sale, and how much they're paying for them. Car has a bill of sale form in car, so you just negotiate it. Number 5, multiple listing service. What is the MLS? God knows what the MLS. By definition, the MLS is an offer of compensation. That's what the MLS is. So it may change in these years to come, but this explains what the MLS is, what information is provided to the MLS, what is the broker's MLS, if you belong to CRMLS, if you belong to the MLS or CLAW. There's also if you're Conejo, I think you're Flex. So write down what MLS you belong to. So then there's this big box area here about the benefits of the MLS. It's like you get more exposure from the MLS. What the impact is of opting out of the MLS, that it won't be marketed to the masses. If you're excluding it from the MLS, you can only market it within your own office. So they need to know that. Reduction, goes over reduction of exposure. Go over this, paragraph by paragraph. Not listing the property in the local MLS, which doesn't cover a geographical area, blah, blah, blah. So make sure they realize, and that, yes, there are sellers who just don't want it there. And, that's their decision. But that limits them, and it limits them because of clear cooperation. So look, Mr. Seller, if you don't want it in the MLS, if you want to exclude it from the MLS, all I can do for you is market it to my office. I can't put up a sign. I can't blast something on social media. Neither Mr. Seller can you, because the minute something goes out and it's marketed, then I have to, by clear cooperation, put it on the MLS. Make sure they realize that. And you have the seller initial it, and then you initial it. Please, people, I don't need to initial this. And no, it says broker. I wish they would get rid of that, but you're sufficient. I don't need all these DocuSigns just to initial this box. Then we go into what clear cooperation is. MLS rules require, you're never going to check do not require, because it does require that residential real property 1 to 4 vacant lots be submitted to the MLS within 1 business day of any public marketing. And it goes on to define what public marketing is in B. So this was page 2. Any questions regarding page 2? All right, I'm not seeing any. Coming soon. Oh, wait, I saw something. Wait. Sorry. What car form are you talking about? I'm not sure. You can unmute yourself, Alan, and ask what car form. For personal property, it's an addendum, but they also have a bill of sale. You can also use that too, in addition to the addendum. Here's what is being sold, and here's how much we're paying for it, and here's your receipt. Coming soon. Now, the misconception when coming soon, I don't know that it's still a misconception, but I hope not. But the misconception when coming soon first came is that you didn't need a listing agreement in place, and you calculated the 17 days. So your listing agreement started 17 days afterwards. That's incorrect. If you're doing a coming soon, the date of your the date that your agreement commences on is the first date of your coming soon, and you have 17 days to keep it there. I think 17. I can't remember it now. It's been so long. But you have that listing agreement has to be in place because it's kind of because you're publicly marketing it. You're publicly marketing it, and that's why the agreement needs to be in place. So make sure that you know that. Now, both CRMLS and the MLS, they both have their own forms regarding coming soon. I would use those forms. And then we have how do you prove that we went over the contract with a client to explain everything if there's litigation? Well, you have this little thing right here, and if you're on the phone or if you're doing a Zoom, as I'm doing right now, I'm recording this Zoom. There's your proof. If you're doing it over the phone, you can show. I had a 45-minute to an hour conversation with my clients. That's when we went over the contract. Why else would you be talking to them for 45 minutes? I don't know. Okay, so seller instructs broker here to market the property and start marketing the property at a beginning date. That's that example of you have the listing agreement starting, and we're not ready to really market it for a few weeks, and you want to exclude it. So that's by date. Or seller instructs broker not to market the property for the entire period. Now, you still need to do an SELM. Even though you check it in the agreement, MLSs still want the SELM. I mean, CRMLS doesn't want it, but they hold the right to ask for it, and so you should have it at your disposal. So that's what. Never, ever, ever, ever check clear cooperation policy does not apply, because it does apply, unfortunately. MLS data in the MLS rules allow MLS data to be made available to additional internet sites. Those are third parties, and those are, it's telling you it could go out to other sites like Trulia and those kinds of sites. So, and it's like property address and whatnot. Now you can tell it, hey, I don't want it to go out to those third party sites. I don't want them to see it. So you would have to do an FELI, seller exclude listing from internet. So that's what the SELI is. And it only goes to the MLS. It is not marketed to anything else. And in your input, when you're inputting your listing, there is a place where to distribute to the internet, something along those lines. And you go either yes or no. If you say no, then it won't go out to those. Okay. Seller elects to opt out as several, once again, the SELI. Okay. Seller representation. Seller represents that unless otherwise specified in writing, seller is unaware of a notice of default. They need to tell you if there's a notice of default, but before you even sat down for this listing agreement, you should have pulled a title report or at least a property profile, because that would show up, and make sure you're talking to the right person who is supposed to be selling this property. So the seller is representing that they're not in default, they're not filing bankruptcy, there's no litigation, all of this stuff. So that's 9 seller's representations. 10, broker and seller's duties. Hey, me as the broker, this is what I'm going to do. I'm going to order reports. I'm going to do my due diligence and find you the best buyer. I'm going to present the offers. There's a place here, seller instructs broker to present offers as soon as possible. Or the seller instructs broker not to present offers until a later date. You can establish that in the listing agreement. A lot of people say, okay, we're going to go on the market on Friday and we're not going to look at offers until Monday. Certain top markets, we used to do that. So you can establish that right here in the listing agreement. Buyer's supplemental offer letters. Okay. So we've all said we do not recommend, when you're representing a buyer, you don't recommend that buyer write a personal letter, because it can expose the seller to fair housing issues. The letter from the single mom who really loves the house and whatnot. Well, the familial status is a protected class. Or the mom, or the letter from the 2 gay guys, seller may be homophobic, and they may not want to sell to a gay guy. So it's not recommended to do these letters, although in a hot market, people are writing these letters. But you need to explain this to the seller. It exposes them to these possible problems. This is the world we live in. Any action is blown out of proportion sometimes. I'm not saying all the time, but sometimes, an innocent act is not taken innocently. So you have to be careful. So the seller can instruct you as the listing agent not to accept these letters. So, and if your seller instructs not to, the default is not to accept them. If they want to accept these letters, then you would check the box, seller instructs broker to present buyer's letters. But hey, look, Mr. Seller, you should be careful here. So that's really important. So you need to go over that with your seller. Any questions on this page 3? I'm not seeing any. Investigation and reports. Seller agrees within 5 days of the beginning date to order all these things. This form is for many different markets throughout the state. Northern California, they do a pre-inspection. That's their common practice. It's not necessarily here. Here's what I would order at the time of the listing. I would order an NHD, a CRESS NHD, because that's going to show if you have any inkling that it's in a, a high or very high fire zone, you should know that up front. Yeah, you really should. I would also order, what would the 9A. Absolutely. Uh um get that out there as soon as possible, because we all know the city takes so long to do it. So I would at least do those as soon as you get the listing. You don't pay for the NHD until the close of escrow. It's paid through escrow. And the 9A, they can use it, the 7620, I think it's still 7620. They can use it for 6 months. So anyways, I would get those out. Deposit. Broker is authorized to accept and hold. Oh, wait, I got a question. I would explain to the seller that the 9A is paid in advance. Yeah, you should. I mean, because they won't order it unless it's paid for. So, and it's an ordinance. People, it's an ordinance. We cannot waive the 9A. And I will only waive the 9A. I've said it until I'm blue in the face. I will only waive the 9A if this is really well, no, I won't waive the 9A. It's the retrofit that I will waive if it's a tear down and it's like horrible. There are pertinent things on the 9A. So a buyer should know about those. So anyways, so yeah, get that out of the way. You're authorizing us to take the deposit, although I'm telling you as an office policy, don't touch a check. Because the minute you touch a check, there's so many things that has to happen, and it's a pain in the butt. So don't touch a check. Say we don't accept. We prefer that it be wired. If the buyer's agent wants to touch that check, and it's not from my office, let them go for it. But if you're in one of my offices, don't touch a check. This explains agency. We all know what agency is, and it's between the brokerage and the seller. And so that I'm going to I'm your representative in this transaction. Talks about dual agency, and because it's with the brokerage and not the agent themselves, somebody else in that same office, it would be considered dual agency. And the broker shall confirm the agency relationships. That's done in the RPA. Potentially competing sellers and buyers. Mr. Seller, my office may be selling a house very similar to yours. I'm just letting you know, there may be other competing houses on the market that my office represents, and that's laid out in the possible representation of more than one buyer or seller. Termination of agency. Seller acknowledges and agrees that the representation duties in the agency relationship with broker terminate at the expiration of the agreement, or if it occurs first, the completion of the transaction. Security, insurance, showings, and audio and video. They're very important. We do not insure your contents. I've told you need to lock up your valuables during the showing, and people may be taking videos, pictures. Oh, I want to show my somebody who's making the decision with me. Very important, but most important, lock up your valuables. And those valuables, as we all learned sadly from Matthew Perry, he would go to open houses and steal pills. One of the most valuable things in somebody's house is their medicine cabinet, is in the medicine cabinet. So make sure they're taking care of that. Photos and internet advertising. We are going to put these all out there, and I can't tell you enough that after a sale has closed, that the new buyer wants all the pictures taken down. Well, number one, you can't take all the pictures down because there is a requirement for at least one exterior picture to be up. That's an MLS rule. So if there's an inkling, especially with CRMLS, if there's an inkling that the buyer is not going to want the photos out there prior to the close, that I'm talking about CRMLS, prior to the close, take those photos down and leave one exterior photo. Because once it closes, I can't do a thing about it with CRMLS. The MLS, on the other hand, they're a little loosey-goosey and they will allow you to manipulate those things. And another thing that buyers need to be aware is, like, okay, yeah, you took them off the MLS, but they also need to, you have no control over third parties. You have no control of Trulia. You know, there may still be pictures out there of your house. So there's nothing that we can do. All we can control is the MLS, and all we can control prior to the actual close on CRMLS. That's once it's closed, I can't do a thing about it. And actually, they won't take them down after it's closed, because one of the MLS rules is that there has to be an accurate historic representation of that listing. And part of that was those pictures. So, so I'm just giving you a heads up. Key safe. If you're going to use a key safe, there's a separate form that they need to sign also in order to use the key safe. Any questions on this page? Not seeing any. Tenant occupied. If it is tenant occupied, then you must use the TOPA form. No, that's for the sale. Sorry, but the tenant has to sign the elaborate on the key safe. It's if there's another form that there's an authorization that yes, you will allow me to use a key safe. That, I mean, it's as clear as that. And if it's tenant occupied, the tenant has to sign that. I mean, that's basically it. Sign, whether the seller wants to sign, doesn't want to sign. Equal opportunity housing means we're not going to discriminate. Attorney's fees in any action, proceeding, or arbitration between seller and broker arising in this agreement, seller and broker are each responsible to pay their own attorney's fees. So if it is an REO, you would check that box. Short sale, trust, if it's held in trust. And if, very important, if the seller intends to include a contingency to purchase a replacement property, say it here and make sure you put it in the MLS. It's so important that if this is contingent on finding another place, that that everybody knows about it. Most of you don't submit the listing agreement in the time period that you're supposed to. DRE regulations state that within 2 days after the full execution of the contract, the office needs a copy of this agreement. That's DRE rules. If I was to be audited and they knew that that there was a listing out there of 1, 2, 3, 4, Main Street, and they asked me, okay, I want to see the listing agreement for 1, 2, 3, 4 Main Street, and I can't produce it, I get in trouble. So 2 business days after the execution of the contract, upload it to Command. Make a deal with your TC. I don't care what you do, or you can upload it yourself. It's not that hard. And just to make sure that we have that contract. And this goes hand in hand. The manager has approval over these things, or management has approval. If there is some wacky deal going on here that that we see within 5 days after execution, we can reject the listing. And I've never seen it, but it's possible. So the agreement shall be binding upon seller and the seller's successors and assigns. Meaning, if the seller dies, this doesn't end. They're still contracted to sell this. It gets complicated, but just know that just because somebody passes away, I think there just was a deal now that not too recently, like in the middle of escrow, somebody passed away. I know that there was a big one at Calabasas escrow and in the middle, and there was a whole, we couldn't, escrow instructions weren't signed, and within escrow instructions, it gives us the authority to have our lawyers go and do this procedure in order to say, okay, everybody agrees we're backing out of this, and the buyer can get their money back. Well, that wasn't signed, so we didn't have the authority, so we couldn't do that. And the buyer was madder and madder and madder, and the listing agent is madder and madder and madder because they were double ending it. But our hands were tied. We had to have this authorization, and the survivors left the country, and it took months. I'm telling you, literally months to get this straightened out, and everybody was pissed off. But we just had no other choice. Okay, dispute resolution. For number one, we need to go to mediation all the time. We have to go to mediation, and it talks about mediation terms and the civil code. Arbitration is not a part of this agreement. Now, if somebody wants to add arbitration, you have to add another form. And we used to include arbitration, but we don't include arbitration anymore because sellers, when arbitration was a part of it, if they had a dispute about with a buyer, they thought because of this agreement they can bring us into it. It got very complicated, and that's why they removed arbitration. But first, if there's an issue with this, you first have to go to mediation. Okay, entire agreement. This inside these, how many pages this is? I think it's 6. Yeah, 6 pages is the entirety of this agreement. So, and ownership and title authority. Seller warrants that the seller is the owner of the property. Remember, you should have gotten either a property profile or a title report. No other persons or entities have title to the property. The seller has authority to both execute this agreement and sell the property. Exceptions to ownership, title, and authority are as follows. And if somebody else has control over this property, then you can put their name there. Legally authorized signer, you're telling them that you are the legally authorized signer and whatnot. So any questions on page 5? No, let's see. Okay. There are disadvantages of not having an arbitration clause. No. Because of the reason I said, because sellers were bringing us in with disputes of buyers that had nothing to do with this agreement. Number 6, entity sellers. If you're a corporation, an LLC, executor of a will, then you're an entity. So this box needs to be checked. It takes the place of the RCSD. So if it's an entity buyer or seller, check this box, and in section number 3, the name of the legally authorized signer or signers is, and they even give you examples in 4 of how to do it, the trust thing. It's like John Doe co-trustee, Jane Doe co-trustee. The entity is the Doe Revocable Family Trust, and the signers are John Doe and Jane Doe co-trustees. So that's who would sign it, John Doe co-trustee and Jane Doe co-trustee, but the seller is actually the Doe Revocable Family Trust. So it's signed by printed name of legally authorized signer. That would be John Doe, and the title is co-trustee. So the name of the seller is the trust or the LLC. And then, so is there any questions there? Because everybody gets confused about that. The seller still is the entity, but the signers, and I think they fixed this in forms. The signers are Jane Doe and John Doe co-trustees, because an entity cannot sign a document. And then if there's more than 2, don't cram more people onto this page. If there's more than 2 people, then you do an additional signature addendum, an ASA, and add those names to that. And then the broker signature. If there is a different broker, if it's a co-broker situation that's representing the seller, then you would add the ABA form, which is additional broker acknowledgement. So that's it. But the main thing I want to stress is this compensation, going over compensation. Commissions are negotiable. The office can set a recommended commission. The office can set a recommended commission, and the office can suggest a recommended cooperating broker compensation, and go over those, with your seller. And nothing is not negotiable, and a seller doesn't have to do cooperating broker. NAR said you can put 0 now. It used to be, it had to be like $1, but I think the MLS will now accept 0. So be on the lookout for that, by the way, because always be checking what the cooperating broker compensation is. And as soon as you're making an offer, print that out, because that's your proof that at the time the offer was made, this is what it was in the MLS. A listing agent can change that at any time and say, oh no, after you've submitted we changed that. And it's like, oh, I'm sorry, but when I made the offer, it was this. I actually had an arbitration with that kind of thing, in that that my agent was the listing agent, and he rightfully was offering one thing. They had signed agreements, and then when it went into the MLS after the offer was made, the compensation in the MLS was higher. But my agent said, when you made this offer, we had an agreement at this price. My seller depended on you for this price at this compensation, but we hadn't had a signed deal, so it went out into the MLS, and he was offering X amount of dollars to everybody else, and we won that. So, anyways, this is anyway. How does a buyer handle a 0 compensation? in the MLS. Get a signed buyer broker agreement prior to showing any property. Then you don't have to worry about it. It's as simple as that. Before showing anybody any property, then you should have a buyer broker agreement in place. Maureen, you had your hand up.
Yes, sorry to interrupt. I was just
Mm-mm.
wondering, can you please go over the buyer? When is the next time you're gonna do the buyer broker agreement?
I
would
just did
love.
it.
I know
It-
I was a part of it, but I still have lots of questions, and I think now that it's actually coming into play, a lot of us
Have you
do.
looked at it again?
Yeah,
Because
yeah.
okay, all right. It'll be a while because I don't want to repeat too much. So
Okay.
maybe in the new year, because I
Okay.
have a feeling things are going to change after the
Yeah.
December release. So if they change things, then probably after they change them.
Okay.
Okay.
Yeah, no, definitely understand. Just I
Okay.
know there's a lot of questions people are asking
Sure.
with that.
I know. All right.
Rich,
Yes.
along those lines, it was helpful for me because I had a lot of questions to attend that free class that you promoted.
Yes.
That was
Right.
fantastic.
Right. Yes.
Hasn't done
CAR is
that in the
giving that
interim.
free class. The code is free 25. I sent out a blast email. Go to that, and it gives you the link of where to find the class, and take that. Yes. So absolutely. That I think I'm gonna when I have some free moments, I'm gonna do it myself. But yeah, take that class. It should be helpful. Okay. Anything else? Let's see. Oh, let me stop my share. All right. Well, I'm not gonna have another class this month because of Thanksgiving. My next class will be in December, the beginning of December. So have a good Thanksgiving. And I will see you later. Oh, oh no, I don't have to do that. All right. Take care. Thank you.